Hi everyone, this is the Lloyd Academy Asia Pacific, Middle East, and Africa Educational Program for 2024. Welcome back to the last webinar session for our July series. My name is Shai from the Market Development Team for Lloyd's Asia, our platform in Singapore. Introducing our brilliant speakers for today, we have Nicholas and Joseph from one of the Lloyd's service companies, Beasley, presenting D&O insurance for distressed companies. Nicholas is responsible for Beasley's international financial lines in Asia. It includes professional indemnity, management liability, and financial institutions. He has over 20 years of underwriting experience in the region and is a regular speaker on various financial lines topics. He joined Beasley in 2017 and is expanding the business in Asia by delivering tailored solutions across multiple channels. Meanwhile, Joseph is the claims manager for Beasley's specialty risks and cyber claims in Asia, which includes international financial lines. Joseph has over a decade of experience in the London insurance market, managing complex financial lines claims emanating from around the world. He recently relocated to Singapore to join Beasley in March 2024 and works closely with the underwriters to provide a leading claims service in the region. All right, some reminders before we start. Please feel free to ask any questions that you may have throughout the session through the comment box at the right corner of your screen, and we will address them at the end of the presentation. This session will be recorded and uploaded online and will be shared upon request. An important note as well, to receive your certificate of attendance and claim or CPD hours, please remain until the end of the presentation and complete the feedback form. Lastly, the views and opinions expressed in this webinar are those of the speakers and do not necessarily reflect the official policy or position of Lloyd's. The information provided is for general information purposes only and should not be construed as professional advice. Okay, without further ado, I'm very excited to hand over the time now to Joseph and Nicholas to start the presentation. Thank you.
Good afternoon. Thank you very much. I'm very delighted to be here with Joseph. Really exciting and excited. I know we are doing a virtual, so and we have 200 plus attendees. We're anticipating 200 plus attendees. So two of us versus 200. I think we need a bit more support. That's why I got our Disney Ducklings here to support us and giving us more motivations and strengths. Now, today we're going to talk about underwriting and claims on distress account. If you are not able to see us, if you are not able to hear us properly, you can put on the chat. We have Wei Xiang on the side who's moderating these technical issues for us. As you have seen the disclaimers, there's always disclaimers before we go into our slides. Yeah. Now to set the stage. To set the stage properly for today, we talk about distressed companies. So what is distressed company? I think distressed company can come in various shapes, sizes, local, overseas, and things like that. But I think in order for us to be more targeted in today's discussion, we just want to talk about three different types of distress risks that we are underwriting, so that we don't go all over places and we do not bring you all around. We want this presentation today to be targeted and beneficial to all the audience. Now, the first and the most common distress is financial distress. For the purpose of financial distress, it could be things like auditors have reservation of comments, auditors refusing to provide comments, P&L losses, EBITDA losses. It creates challenges when you're writing a loss-making companies for the last 10 years. They have been loss-making. How am I going to be underwriting them again? Where negative gross losses, which means your gross income less cost of goods sales is negative. So every single goods that you sell is making a loss to the companies. That's a very bad news. That means you're burning your sales There's only a few situations where companies are doing that. Yeah, and in those situations, it is tough to be a long-standing strategy. Negative cash flow is something that's very important. A lot of people neglected that. Negative current liabilities or negative net worth, which technically means your company is insolvent. So that's a technical insolvency companies. The other part that we have to talk about is economical cycle. So in different cycle, be it recession cycle, an industry going through ups and downs. For example, the chip industry has chip prices. Semicon chips has different prices, different cycle. The coal prices has a cycle. The oil has a cycle. Or it could even be pandemic, where as a pandemic, we have to redo our underwriting guideline. We have to think about what's the new emerging risk. How do we deal with all these new emerging risks? Geopolitical is all right in our face all around, and this year there's no shortage of drama all around the world. So it's for everyone to have their own view, right? And a third and kind of distress risks are those with claims, those with inquiry, those with investigations, or even those with filing us circumstances, shareholder having distress, shareholders during a privatization, shareholder raise their hand and say their disagreement and wants to register their interest as disagreed. Yeah. Or an, a proper securities claims in the US. So in all this framework, we like to bring you back into this discussion of how we're going to look at these three main distress. Joseph over here will talk about some claims example first. We want to do the claims example first because we want to set the stage. We want you to feel what are the distresses that and what are the claims that can come up. And then we do underwriting after, which is how does underwriters look at them? How can we overcome this together with our brokers? Now, with that, I pass over to Joseph.
Thank you, Nick. So I'm going to talk about claims. So firstly, I'm just going to do a high-level overview of the Beazley core claims principle. So a Beazley claim is an important part of our insurance offering, and we understand the importance of having claims expert assisting our insurers during the uncertain and stressful times of a claim being made against them. And that's quite important, especially for individual D&O insurers who are potentially exposed to personal liability that could impact their personal wealth, reputation, and well-being. So with that in mind, we ensure there's a claims process for our insured that works with them, and that's guided by our three core principles. So firstly, being bold. So we are experts in what we do, and we have a lot of claims experience which you can use to assist our insured during the claims process. Also, we're empowered to make quite decisions quickly, and we don't shy away from having personal interactions with our insurers and brokers. In fact, we strive to work in close partnerships with them throughout the claims process. And secondly, we do the right thing. So we are very customer centric, which means that we are very responsive, open-minded, and fair to the insured, which doesn't just mean kind of making coverage decisions quickly and paying valid claims promptly, but also working with our insured throughout the life cycle of the claim to achieve better outcome for the insured. And then lastly, we strive to do better. So our claim service doesn't just begin and end with a claims notification and conclusion, but we, after post-claims, we have discussions to see what we've learned from the claims incident, any feedback received, and any trends we are seeing, so we can provide better service to our insurers going forward. So that's our kind of core claims principle, and then I'm going to move on to talking about D&O claims involving distressed companies. So this is my quote for the day. So directors of distressed companies must exercise heightened vigilance and carefully manage interests of various stakeholders. And by stakeholders, I'm going to cover the creditors of the company, the shareholders, and the employees. So starting with the creditors of the company, which is essentially brought by the liquidators. So when the company enters into financial distress and becomes insolvent, liquidators are appointed to kind of forensically investigate what's happened and explore avenues for creditor losses. And that includes kind of looking at what other kind of management decisions that the directors have made during their directorship, and also if there has been any mismanagement decisions that has caused the creditor losses that could lead to liquidator claims being made against the directors personally for breach of director's duty, which could open up the directors for personal liability and could implicate side A coverage under the D&O policy. And a good example of that, a recent case involving a company called Inter-Pacific Petroleum. There's a Singapore High Court decision recently which held the ex-director responsible or liable for failing to kind of investigate various red flags involving fraudulent transactions that were taking place within the company. Even though the director wasn't actually involved in the fraudulent scheme, therefore was considered innocent, he was nevertheless liable for negligence or essentially sleepwalking in his job, allowing this fraudulent scheme to take place right under his nose. And the damages awarded in that case was quite astronomical, nearly 200 million Singapore dollars plus interest, and that's currently subject to appeal. And my understanding is that that company didn't have any D&O insurance in place. So it doesn't just kind of highlight the importance of having a D&O policy in place for events like this, but also the importance of directors constantly acting vigilantly and competently acting as a director with a good understanding of what's going on in the business and the industry it operates in. And then the second type of kind of liquidated claims that we see commonly involve allegations of wrongful trading. So normally the directors have a duty to act in the best interest of the company and its shareholders. But once the company enters into financial distress and insolvency is at risk, that duty gradually shifts towards acting in the best interest of the creditors, and the failure to do so at the right time could result in liquidated claims against the directors personally for wrongful trading. And a good example of that is kind of what Nick talked about earlier about pandemic cycle. When COVID happened, a lot of industries, including kind of travel agencies and cruise operators, suffered financial distress and entered into insolvency. And we had easily handled kind of liquidated claim against a failed cruise operator firm, and the liquidator issued proceedings against 18 different directors and officers involved for wrongful trading, essentially trading whilst insolvent, deepening insolvency to the detriment of creditors without any legitimate plans or any profitability. So we investigated and confirmed coverage quickly and worked with various directors and the defense counsels to come up with a strategy to resolve this claim before it goes too far to the court proceedings. We ended up making a good settlement of mediation, saving everyone quite a lot of money, and achieving a really good outcome for the directors involved. So that's a good example of where kind of D&O insurers and the D&O insurers can work together to achieve a good outcome, how we can kind of add value in the process. Yeah, so that's the kind of common liquidated claims that we see in distressed companies context. And then moving on to the shareholder actions. So as you can imagine, during the times of financial distress, that there's a lot of volatility in the share prices, especially for publicly traded companies. And that can often result in the shareholders and the plaintiff law firms initiating kind of shareholder class actions or claims against the company and the directors involved for allegations of breach of securities law.
These are for listed companies?
Yeah, listed companies, and causing loss to the shareholders on the share price and the market cap. And the examples of the breach of securities law could include non-disclosure or misrepresentation of material information about the company affairs or the financial strengths of the company, or whether that's through financial misstatement or financial irregularities that cause shareholder losses. And that would typically trigger coverage under side B and C under the D&O policy. It's quite common in areas like US, North America, and Israel, which the Asian businesses with operations there should be alive to. And also, shareholder actions can also implicate side A coverage on the D&O policy as well. In certain jurisdictions by way of derivative actions, which is a tool in certain areas for shareholders to stand in the shoes of the company, pursue directors for potential wrongdoings.
Why is it that side B and C cannot be triggered for shareholder derivative actions?
So in certain jurisdictions, it's against the law for the company to reimburse the directors for derivative actions, because essentially in derivative actions, it's the company that's bringing the claim against the directors. So it's a bit circular, it's a bit illogical for the company who's a plaintiff to then indemnify or reimburse the defense costs of the claim that the company itself has brought. So that typically is covered under the side A policy.
Right.
Yeah, and traditionally derivative actions were brought normally as a tag-on to securities actions, normally involving corporate governance issues, which doesn't really have any monetary value. But we've seen more recently derivative actions being used as shareholders as a means to recoup losses that the company has incurred due to management wrongdoing. So a good example of that, I think, when Nick mentioned about claims impacting distressed companies, for example, in the pharmaceutical industry, a lot of pharma companies incurred billions of losses dealing with the high-profile crisis issues like opioid scandal, which has caused them billions in terms of regulatory fines and claims payments. And also in the financial services sector, certain financial institutions having issues with anti-money laundering breaches, systemic breaches, that's cost the banks quite a lot of money. So we've seen it in those contexts, the claims developing into a derivative action against the directors, essentially for allowing that to take place under their management, of failing to exercise the duty of care and skill in supervising the company properly and making sure that kind of losses aren't incurred by the company. And so that's and I understand that maybe derivative actions are not that common in Asia region, but it would be very highly relevant to Asian businesses who have operations in perhaps North America or Israel, where those mega derivative claims are becoming more prevalent.
I think we do see derivative action in Asia because, as we know, class actions and securities actions in Asia are less common because of the need to finance for the litigations. But I think from a derivative actions basis, having shareholders asking the companies to take legal actions against directors, I think we see that a lot more common because the company will be able to finance the litigations against the directors. I think it's also very important. I think I hear you on side A is actually been triggered for derivative actions because of they are non-indemnifiable action. because there's no point for the company to reimburse the directors to pay
Yeah.
the companies, right? So yeah, that give. I always remember in all of D&O, Flight A usually would not have a deductible, and that is important, I think, in this whole conversation.
We have one question online which states, are companies legally able to cover shareholder derivative action in Singapore law?
Again,
The question is, are companies legally able to cover shareholder derivative actions in Singapore law?
right. So I think the question was, is the company able to cover? I think the word companies here means the insurance company. Is insurance company able to provide insurance where directors are being sued for under derivative actions? If we go back to the Company Act, then the fundamental is that uh, they should be free of gross negligence, and and there are certain requirements within the Company Act which stipulates at which instances the policy can then reimburse. So, but what is important is that at the point of extending the defense, the directors will need good lawyers to provide for their defense, and all the way up to the uh, judgment, right? There are circumstances within the company law which restrict the coverage, yeah, and we will have to refer to that.
Unless there's any other questions, we'll move on to the final kind of stakeholder that I want to talk about, which is the employees. So as the company gets into financial trouble, the company and the DNOs could make decisions to lay people off, make people redundant, as part of maybe exercise to reduce expenses or as part of a restructuring process to avoid insolvency. And we could see that that could potentially lead to EPL claims against the company and DNOs, especially where when there's a financial distress, a lot of people are kind of under stress and panicking to save the company, and perhaps they maybe take rush decisions to lay people off without necessarily following the due process or the applicable law. And or potentially engaging in some discriminatory behavior. So it's something that I think the DNOs and the company from DNO policy perspective could face employment EPL claims.
Right. Thank you.
Yeah.
Thank you,
Yeah.
Joseph. Really, yeah. I think he shared with us some of the claims that we've seen in the market. Some are with us, some are what we learn of, some examples of things happening. Right. I think with all these claims, possible claims that may float out from distress, how do we as underwriters come about and look at the matters? I think the first part is from an underwriting perspective. I think we also want to make a quick introduction of BISLI. Fundamentally, we are a specialist insurance company, so we provide we're here to provide tailor-made solutions. We want to be bold. We want to be able to go in our decision. We want to strive for the better, and at the same time, we want to do the right thing. I think saying doing the right thing is easy, but later, as we come out with, as we go through some of the underwriting decisions, that becomes a lot tougher. We want to be fair to our customers. Now, innocent directors of distressed company actually has greater needs for protections. We have over the last 7 years, we've seen how the market has changed. We've seen pandemic cycle. We've seen financial challenges. We've seen claims escalating and then claims subsiding. But what we have experienced during this period is we have brokers and we have insureds coming to us to seek for alternative solutions when the company is going through some distresses. I think it is important that directors of such natures find a solutions to protect their personal assets. Always remember, D&O is all about your individual personal assets. Yeah. Now, when we underwrite, sometimes we talk about three different scenarios of distress. So we start with financial distress, right? A lot of time we see submissions for bank insolvent company. We see submissions for companies who breach their loan covenant. We've seen submissions for a variety of things. Now let's take a step back. What is insolvency? I think the question is, what is insolvency? Insolvency is not about P&L, balance sheets, blah blah blah. Insolvency is all about cash flow. It's all about cash flow. It's the ability to pay debts when it's due. As simple as that, but it's all about cash flow. If you have loan coming up in 6 months' time, you have loan coming out in 12 months' time, and if you have structured a loan replacement, if you have structured a shareholder capital injection, there will not be a cash flow issue. Insolvency comes about when there's a break in cash flow. So regardless how strong your balance sheet may look, regardless of how profitable your company may have operated in the past, but if they are not able to recover the receivables, and if they are not able to generate enough cash to pay out their expenses and loan, they get into insolvency claims, right? So with that context, as underwriters, what is the best solutions and what's the most common solution a broker will see? When you see a company that is in financial trouble, I think when you go into the market, you will see a lot of quotations that comes back with insolvency exclusion. Is that the best way to solve the problem? Is that the best way to underwrite yourself out of it? I think from my perspective, as far as possible, I would try to avoid using insolvency exclusion, because unless absolutely necessary and there's no other way of addressing and pricing the risk, we shouldn't go to the extent of it just the convenient way of, let me put an insolvency exclusion. I pretend that now the risk is writable. Because I put an insolvency exclusion, the risk now becomes good, because I will justify to my referral desk, if there's any claim on insolvency, is good. But the real fact of matter is, it's not as simple as that. From a wording perspective first, insolvency exclusion comes in various shapes and sizes, right? Having insolvency exclusion there on the slip says nothing. You have to read into the content of the insolvency exclusion. There are insolvency exclusion that says, well, once the company is proven to be insolvent, all the claims, the policy will not pay any claims that are arising after the company becomes insolvent. We also have a version which says, well, the policy will not pay anything relating to insolvency litigation claims, wrongful act. Right? We also have another version which says that the policy will not pay for any claims arising from creditors or liquidators. Now, there's various shapes and sizes of this, but my honest opinion is it doesn't solve the fundamental problem. First, it is hard. It is very, very hard to determine at what point is the company insolvent. Yes, you will say that the company is insolvent when the total liability exceeds total assets. You can also say the company is in the stage of insolvent when liquidator has been appointed, when court has ruled that they are insolvent. You can also say that the company is insolvent when the claims is being brought for insolvency matter. And we even have situation where if you look at the submissions and the financial report shows that the company is in a negative equity situations, and there may be a insolvency exclusion which says this policy shall not pay any claims after the company is insolvent. That creates contradictions. So the real way to really look at all these matters on financial distress is to really understand the financial condition of the companies. What you've seen on the financial report, what you spoke to with the CEO, CFO, understanding their refinancing deal, understanding their business dynamic, understanding the cycle. If the situation rests on them having confidence to provide refinancing, then at most maybe instead of putting an insolvency exclusion, you would like to have an exclusion to say that in the event that refinance fail, then we'll exclude claims. But even to that extent, I think we need to do our homework better as underwriters. We need to provide solutions in a broader mindset. Always talk to the client, always talk to the insurance, because the insurance is in the best position. The financials is outdated. You can have projection, you can have business plan. You ask for business plan, you understand the situation better. But in a financial distress company, it is very important to speak to the client, because the client will tell you that certain shareholder is going to inject, they're going to have a white knight, the company's operation is going to be transformed, and we may restructure the company, we may restructure the policy then in such a matter that it will align with the company's new business, new objective, new shareholders, and new risks. Always remember, the buyer of the insurance will always be concerned about going forward risks. And if they have a change in shareholders, they will be less concerned about their previous life. Which means that as a diligent brokers, then it is important to arrange alternative runoff for previous shareholders and previous management. Yeah. So that's how we look at financial distress. We will always try to challenge. We will always try in business. We will always try to challenge ourselves and ask ourselves: is insolvency exclusion really the right way and the best way to address the claims? Right. We have to be fair to the customers who's paying us the premium for us to underwrite the risk. If we collect sufficient premium, then we should be there to take on the transfer of risk. But at the same time, we want to be able to ensure that the policy provide sufficient cover for the client. I think we want to be mindful that we are not in a positions where we provide a policy that has so many exclusions that the paper is being written on is worth more than the policies. You don't want to be we must be able to be in front of our client to explain, for paying us the 10,000, the 100,000 of premium, what is the cover that we are taking on? That is very important. Any question on financial distress? Another way of approaching financial distress is that, well, go find out what causes the financial challenges. Right? We have to be a bit more probing. What has caused the financial distress? What has resulted in them in current situation? Did they overinvest? Did they buy something that's not worth? Did they price their product wrongly? Was their cost too high? Are they changing it? Now, knowing what's the situation, and if the client is very upfront and be able to share with you how they're going to change and move forward. I think it gives us confidence in writing the risk. But if you put us in front of a client and the client said, I don't really know what has caused caused the company to be in such a bad shape. I don't know. Oh, I inherited this. Then it gives us very, very little confidence on providing. There are many reasons why a company is in current bad shapes. Once we know the reason, we can underwrite out of it. We can take on the risk, or we can provide very targeted exclusion for certain things that has happened in the past. Yeah, so that's very important. Let's work harder, try to find out what's the cause, how did they end up where they are today. The next will be to underwrite when we are within a cycle. So during pandemic, so what are the various cycle? What are the various exclusion you've seen for cycle? For people as young as me, you will know what's Y2K exclusion. Y2K is the best symbolic exclusion in any D&O underwriters or in any insurance underwriter life who are more than 50 years old, right? So, anyway, Y2K appears as one of those exclusions that's prop-based and was meant to be there to address the cycle, the incident, the events of crossing year 2000, right? But in recent years, we've seen exclusion like cyber exclusion, right? There was a period where a lot of D&O policy put in cyber exclusion because cyber becomes unclear where cyber policy should sit, and it becomes unclear how cyber should be reacted within all policy, including D&O. But the fundamental is, if you look at D&O, it is meant to be a catch-all policy. It's meant to be a catch-all policy, which means that we are here to provide the innocent individual directors for litigations and to protect their personal assets. Right? If the situation has arisen and it does affect the individual, I think it's our responsibility to provide correct coverage for that. The more recent kind of exclusion you see is RUB exclusion, Russia, Ukraine, Belarus, or you may even see an exclusion on PFAS in the future. It's quite similar to when asbestos was out, kind of thing. I think when we are going through cycle and when we are being asked to look at emerging risks, and we need to really go down to ask ourselves two questions. Is this exclusion really going to solve the problem? And is this exclusion really meant anything at all? I used to see exclusion that says, well, this policy shall exclude anything relating to the Russia war, for example. Now, how do you then consciously justify? The drop in share price may be resulted because of directly or indirectly because of the war in Russia. A breakdown in the supply chain could be directly, indirectly due to the war that Russia has. Or there are so many connectivities that could link to these conflicts. That it is very, when you put a very broad exclusion, when a claim comes about, can you really trigger this exclusion and stand in front of the client as a claims manager, just standing in front of the client and say, hey, we meant to exclude anything relating to the conflict in Russia and Ukraine. whole world is affected by the conflict in Russia and Ukraine. The price of the some of the food, the price of some of the oil are affected by that. Does that mean that your exclusion is going to be triggering for that? So it's very important when the market try to put a very broad worded exclusion. Sometimes even though you manage to put into your policy, at the time of claims, it may not be as easily, or it may not be able to be applicable, right? So we go back to the whole concept. Let's get deep into the cause, the root cause. If the matter is due to the conflict, there may be a sanction issue. We put out a sanction exclusion for specific matters. If due to the conflict, price of the oil has now reached a level that will cause insolvency to the company, then we address it on that matter. Which I think when we underwrite through cycle, we have to be very conscious and ask ourselves real questions. What is really affecting the risk? Okay. Any question on underwriting on cycle? No. And third is the most exciting is claims. Whenever there's claims, whenever there's claims, like, oh yes, claims is here. Life is good for underwriters because we're going to increase price by 25% just because there's a notification. It's not. No, it doesn't to us. It doesn't work that way. We have to be fair, right? The claims and the circumstances to us is showing that it may tell us of possible weakness in the risk that we may not know about in the past. Now, because of a claim, because of an EPL, we understand that their hiring practice may be wrong. Because of derivative actions, we may find out that their ESG guideline may be wrong. Then the whole idea is to address and understand from the client what they are doing to address those issues. It is not because there's a circumstances, there's a claim, it's a good opportunity for it. As a simple mathematics, nobody will be able to pay back, for the kind of claims we pay out because these are protections that we offer. So it is very important when we underwrite for risk with claims, we underwrite in terms of what has gone on, what has gone wrong, and what is important to make it right again. I think pretty much what cyber kind of underwriters are doing. Oh, there's an incident. How do you? Oh, there's a crime. For crime underwriter, there's a crime. Or how do you tighten your controls? How do you test your controls? A lot of people forget that. Yes, even for D&O, when they file claims of circumstance, it is important to understand what is the issues. If the issue is two frictions within the companies suing each other's, and causing dispute, then this is not going to go away. It is not going to go away, and I will be standing in front of your client and tell them this dispute is not going to go away unless, and as such, it becomes uninsurable. And we will have to be direct to your client that it's uninsurable. But if it's because of an overlook by a CFO that causes losses to the client and they have sued, then that's fine. We understand what has gone on. Now, the other matter is there a difference between claims and circumstances, right? When someone files a claim and someone files a circumstance, or when I think you'll feel that from a business perspective, we want to be very conscious about the progress of claims and progress of circumstance. There may be situations where disgruntled shareholders register their dislike, register their disagreement with privatizations, and that is and reserve their rights for actions in the future, and that by itself may be considered a circumstances. And if that is a circumstances, then is from an underwriter perspective, we have to be mindful how long this whole process will stretch, because when a listed company go privatizations today, disgruntled shareholders has registered their disagreement and reserve their rights to bring actions. When do you think they will bring an actions? They will bring an actions only when the point in time where they can prove that the price of privatization is inadequate, which means that in the next valuation date. So when is the next valuation date? Is the date where the company get into an IPO again, or the company PE value the companies and sold it off into the market. So this whole process takes 6 years, 5 years, and the circumstance stretch long. And when that happens, as underwriters, we have to be mindful and understand what are the timeline that we're talking about. We cannot close our eyes and say, just because they file a circumstance, that means that there's no claims paid. I'll continue to underwrite them as if it's claims free. It is very important to go back to the root cause. What has triggered the situations and how things has happened. With that, I give a pause the presentations and we go into Q&A.
There are 3 questions online. The first 2 is quite similar, so I'll just combine them. Just feel free to give an answer. So the question is, are there any emerging trends in D&O insurance coverages specifically tailored for distressed companies in the APMEA region?
Is there increased trends? What we are trying to be mindful, we are trying to be mindful when we are underwriting in this region is how the geopolitical, not just in this region, but also in the UK, US, Russia, Ukraine, affects not just the company directly, but affects the price of the commodity, the price of the supply chain that would then affect the company, resulting in financial impact on the business. Yeah, we need to be aware and sensitive to all these situations. Currently.
And I think on the claims side, we haven't seen any real trends as such, but the case I mentioned earlier, the Inter-Pacific Petroleum, I believe is one of the very first or very few cases in Singapore where the court has pierced the corporate veil, found the director individually personally liable for significant breaches of director's duty. And that's currently under appeal, but it'll be interesting to monitor the progress of that claim to see whether that kind of develops into a claim in due course.
Okay. The next question is, philosophically, the intention of transferring such risks from the insured shall be understood first. As long as the insured is conducting based on good faith and not violating any laws or regulations, claims shall be granted. Is it correct?
So can you repeat the question, sir?
So the question is, if the insurer is conducting their actions based on good faith and not violating any laws and regulations, claims shall be granted. Claims coverage shall be granted. Is it right to understand it that way?
Let me probably start with. I think this is a very good question. It address a fundamental issue is in a DNO policies, the insured is actually an individual who is making multiple tough decisions every day. And they have to weigh balances when they make decisions. But at the same time, when they are making decisions, they are putting at risk their personal assets, their own houses, their own children education fund, and so on, by making all these decisions. And rightfully, this policy, the intention of a DNO policy is to provide protections and peace of mind to all the individual directors who are making tough decisions, so that in the event where there is an allegations, there's a source of insurance to help them fund their legal fee to defend their case. And in the worst situation, if the court rule that they have to pay compensations, provide that, or in most situations where there can be agreed mitigations or agreed resolutions between both parties, then we will also be helping the individual insured. When it comes to coverage, whether policy should be paid or not,
Yes, I think the key word there is in good faith, and as opposed to like bad faith or perhaps fraudulent actions. So, yeah, provided that kind of it meets the definition of kind of the claim, wrongful act, and it's normally under DNO policies quite a broad wrongful act definition, including allegations of any error, omission, breaches caused or committed by the individual director. Then on the face of it, the DNO policy coverage, the insuring clause would be triggered, provided that he was acting in his capacity as the director of the insured company. Yeah, and we would be kind of paying the defense cost, subject to the defense cost being incurred with kind of prior consent as may be required under the policy. And we will be kind of discussing kind of who the right defense counsel is who can appropriately defend the insured director for the alleged breaches of kind of director's duty. And to the extent that there's any kind of the legal advice from the defense counsel suggests that the insured is exposed to liability, albeit it's not bad faith but good faith, a kind of negligence type of situation, then we'll kind of discuss the merits, strategy, and risks involved, and kind of agree an appropriate strategy, and if that is to kind of resolve the claim without it going through the court process and potentially exposing the insured to significant legal liability for compensation or damages, then we would cover that compensation or resolution.
Yeah, and we welcome you to just give us a call. Yeah, we don't really like emails. Yeah, just give Joseph or myself a call and chat through stuff. Yeah, because it's important. It's important that every situation is different. But for those who have dealt with BC, you know that we're pro claims, so we will try to find where are the available coverage that your client is entitled to. We're not going to be shining away from our responsibility.
The last question. Claims made nature and prior X coverages make DNO and EPL risk assessment much more comprehensive and difficult than other lines. How do you as an insurer ensure that you do not pick up certain things that you do not want to cover?
Wow. Now, as in all insurance, right? We're here to provide cover for the unknown, right? We're not here to provide cover for the uh, known, right? Now, we are not here sitting against your insured. Yeah, don't portray underwriters as here sitting against your insured and trying to formulate all kind of conspiracy theory that could happen with possible claims that can come out and then start slapping exclusion on every single conspiracy theory scenario. That's not our job. No, our job, and if anyone thinks that that's the underwriter job, that's yeah, you need a new job. Yeah. That's not an underwriter job. You will see that the policy spirit is uh, a catch-all policy that's meant to provide a safe and yeah, sleep easy for directors. Now, what has been known, the policy will address them definitely. If there are litigations that are already happening, the PMP dates will address them. If there are known claims, then obviously if the claims has happened uh, before the Power Act or whatever, as underwriters, when I look at risk and I underwrite, my first instinct is not to think of all the possible claims and start excluding. My first thing is right. How is the corporate governance? What industry are they in? What challenges do they have from their business because of this industry? And to be able to address that, you should really see that we are there to, yeah, that's good. But a very simple Google search will list out all the issues. That's if the issue is big enough, it will be on Google. If it's not on Google, it's probably not big enough for you to consider that it will trigger your DNO policy. That's a very simple guide to what's actually big enough.
Thank you, Nicholas and Joseph. I think just one last question for me, just a very quick one. What is one key message do you want our audience to take away from this session?
I think from underwriter point of view, the one key message I want to share with the audience is that don't be don't be don't take the easy way out of when you're looking at distress account. Go and find the root cause and dig deeper and to be able to meet the client, have that eye to eye connections and talk. Look at the client in the eyes and hear them out. Yeah, they are the expert in the business and they will give you a good idea of what's happening.
I'll say my key message would be on from claim side, kind of you're always open for a discussion, whether there's an actual claim circumstance or anything related to claims on whether it's DNO, distress risk, or the types of claims queries. So feel free to reach out.
Right. Thank you so much again, Nicholas and Joseph, our speakers from Beasley, and also to Wei Shang as well for helping us on the technical bit. Thank you all for attending today's DNO Insurance for Distress Company session, the last one for July. And we look forward to having you again in our next session, which will be in August. So we will be discussing lots of different key issues in insurance and risk management there. All right, so we have come to the end of our presentation. Please fill out the feedback form that I am sharing after this call to claim for your certificate of attendance. Thank you once again, everyone, and enjoy the rest of your day. Bye.
Bye bye.
Bye.